IRS, and there's work done at Postal. But by and large, both the prosecutorial, the entire prosecutorial function and most of the investigative function happens in a single agency. So unlike Katyal, I'm talking not about two agencies being empowered to fight one another. I'm talking about how can we get the Justice Department itself to fight itself, which is a much more challenging and I think in some ways tricky endeavor. Okay, so the one thing I want to start, and again, I'm going to wrap this up in a couple minutes. I think there actually are intra-agency checks in the Justice Department itself that are under-theorized, under-examined, and probably deserve a little more attention. Let me list three. One, you have the checking function of prosecutors over agents. Talk to any self-respecting agent in the world, law enforcement agent, and ask, would you rather take this next step without talking to the lawyers or after talking to the lawyers? And forget about law enforcement. This is just a truism about life, right? Keep the lawyers out of it. We're happier, things work faster. So that's check one. That already is pretty prevalent in ECPA, I should add, because ECPA has all sorts of things like subpoenas and court orders and warrants that an agent can't do without knocking on the door of the U.S. attorney. Two, prosecutors in the field, in the assistant U.S. attorneys and the U.S. attorney's offices, tend to be very different than prosecutors at Main Justice. Right? They have a very different role. They're actively litigating and prosecuting and investigating live cases that they need to ultimately prosecute someday. Main Justice, and particularly the components of Main Justice that think about ECPA, they tend to be much more about, let's take the long view, let's think about the big picture. I've always said that the unit I was in, CSIPS, is the best training for a future law professor because we never found any of the criminals, so we would just sit around in the hallway saying, what if we ever found a guy who argued X? And then the next time we looked down at our watches, 4 hours had passed as we had debated it in the halls. And I'm sure Rick remembers a lot of those debates. The third, and the one that I think has received the least amount of attention, is that components in the Justice Department often will disagree with one another. And here's the kind of joke I had in the title, which is, this is a gentleman, oh, sorry, let's skip this. I'll come back to it in a second. There's a gentleman named, this thing is really not working, Mark Eckenweiler. Mark Eckenweiler started his prosecutorial career, I believe, in the computer crime and intellectual property section. He taught most of us everything we know about ECPA. And about 3 or 4 years ago, he moved from the computer crime section over to the Office of Enforcement Operations. I'm sorry I'm making you get so far into the weeds of the inner workings of the Justice Department, but I think this is a very important structural shift. You took all of the knowledge of ECPA and you moved him to a different part of the Justice Department. Now, it helps that he's also extremely fair-minded, extremely intelligent. There's a picture of him the day he won Final Jeopardy. It helps that he is the kind of best model, in my opinion, of the engaged civil servant who is doing his job for the people of the country and not for the political masters that happen to occupy the office above him. So in many ways, I really do want Mark Eckenweiler involved in more of these debates, but a little bit more seriously, I would love it if we could find mechanisms to encourage the Office of Enforcement Operations to engage in more ECPA debates with the computer crime section. What do they do now? The Office of Enforcement Operations is, admittedly a little obscure to the public. Anytime you need a wiretap in the federal government, that wiretap has to go through OEO, and it often has to cross the desk of Mark Eckenweiler, right? And I bet there are FBI agents out there who will tell you they never lose sleep about the judges in their districts when it comes to wiretap. The only thing they hate is getting OEO approval, right? The real privacy protection in many ways often happens in the bureaucracy of the Justice Department, partly because there are judges out there who are just so committed to getting crime off of the streets that they're a little, and less familiar, frankly, with some of these statutes than the experts who think about this all the time. Now, for those of you who follow national security and FISA warrants, there's a parallel thing that happens in the National Security Division. It's a separate office called OIPR. And I think what I've just said is probably true on that side as well. You would much rather face the judge at the end of the day than the internal DOJ bureaucrat who is asked to approve this. Okay, so here's what I want to do. I want to find mechanisms that allow us to encourage, accelerate the intra-branch fighting that sometimes can happen. I want the field much more often to be responsible for going to main justice to seek either, there's three things you can require: notice, consultation, or approval. And the names kind of suggest that this is an escalating scale of the level of bureaucracy you must engage. Notice, consultation, or approval. Congress has done this before. Congress has enacted statutes. And remember, there's a little bit of a separation of powers problem here, right? It's a little awkward, and especially for those of you who have followed debates over what they call the unitary executive, for Congress to be micromanaging the Justice Department, but they do it all the time. How? They say in the statute, you cannot take this step until you get the approval of the Attorney General, the Deputy Attorney General, or his or her designee. And what that usually means is I'm going to filter it down to the appropriate section. So here are some examples. The last one's a really interesting one. The use of pen, this is all from the United States Attorney's Manual, by the way, which is online because of FOIA. The use of pen registers to collect all or part of a URL is prohibited without prior consultation of CSIPs. Okay, so step one is let's do a lot more of this. Wouldn't it be wonderful if we had a new provision in ECPA that said anytime you use any ECPA process, you need to get consultation or even notice, even the lowest form, notice to the Attorney General or his or her designee. Okay, that's option one. Let me finish the thought, and then I'll conclude. But number two, might there be interesting ways for us to send this to OEO as well as CSIPs? So my understanding, and I haven't talked to Mark Eckenweiler about this, he has no idea that I've put his picture up here today. My sense is that ever since he's left the computer crime section, there's been a lot of unhealthy turf war fighting over the different parts of ECPA. And that some things are now gravitating upstairs to where X sits, others are remaining on the 6th floor with my former colleagues in CSIPs. But by and large, there's very rarely the chance for both of these sections to weigh in on a decision. And in fact, you can see this every time there's an ECPA brief that comes out of the Justice Department, flip to the last page. I do this every time. In cell site location, it tends to say Mark Eckenweiler. When it comes to ECPA pen register stuff, it tends to say Nathan Judish or Richard Downing, which means it's still down in CSIPs. Wouldn't it be better if we somehow, and maybe there's no way congressionally to legislate this, but maybe we can exhort the Attorney General to do this. Wouldn't it be better if both CSIPs and OEO were brought to the table on those things? Okay, what I plan to do is raise a bunch of objections that I'm expecting and responses, but instead I'll be coy and leave those for Q&A. Thank you. Jenna?
So I just had a question. How does your argument play out at the state level?
Yeah.
So that applies to any law enforcement agency in the United States.
Yeah.
State local law enforcement are not going to go up to these.
Yeah, no, it's a really good question. So the question is, does this play at all when we're talking about the state role with ECPA? Because remember, although it's a federal statute, it empowers all sorts of state activities with state judges and state prosecutors. Couple of responses. One, it wouldn't be unprecedented, probably a little unpopular, but unprecedented to have the attorney generals of the states required to every so often go to main justice to talk about the kind of policy that they're implementing. The second thing I would say is I'm sure there are ways to kind of play this out in the states as well, although it would require someone other than me to know how California, for example, structurally works. And three, and boy, this is just something that's probably not true, but I'll say it anyway and say it confidently so you believe me. Three, I still think when it comes to cutting edge, pushing the envelope, ECPA issues, a lot of it is happening through the FBI, the Secret Service, and the federal agencies. So maybe if we could at least like clean the house a little bit on the federal level, we can worry about the state level in different ways. And none of this is meant to replace ECPA reform and digital due process. It's another set of tools we might try and bring to bear. I mean, it depends on what verb they use, but you know, the Justice Department can put out a memo that says must or shall instead of should or isn't it nice or here's something to think about. And I don't know enough about how kind of the USA Attorney's Manual and other internal processes are promulgated, but that's my guess as to what happened there. That main justice took what we all would think is a more privacy protective view, but they gave the field the discretion to kind of fight it out in the individual district. You just think that, oh really? Well, then that's a different problem altogether. That probably violates some internal, I don't know enough about this specific example, but it sounds like a violation of at least internal processes, which is exactly the kind of thing that I hope functions well for an idea like this to work. Yeah.
Maybe I missed something, but you put so much emphasis, I saw so many references to this directive model that I wonder how much your argument depends on his personal attributes,
Right.
and how much of it really applies institutionally regardless of his tenure.
Yeah.
And if it's micromanaging to say it has to go to OEO,
Yeah.
seems to be all the more micromanaging to say it has to go to him regardless of what job he happens to have at the moment.
Boy, wouldn't that be great? No, I've got a bunch of responses to this. First, I'm being a little bit sensationalistic for the purposes of the talk.
Yeah.
The paper won't be entitled "Let EC Decide Everything." That's number one. Number two, I firmly believe that this whole idea of kind of the laboratory of ideas and engendering dissent means that if you throw two different agencies or sections at this problem, there's always an increased likelihood that they're going to disagree, no matter where Mark Eckenweiler sits or if he sits in the Justice Department whatsoever. Two eyes, in this opinion, are better than one. I was talking to Julia Angwin about this last night, and we both thought of, the cathedral and the bazaar, the idea that open source software is better because with enough eyeballs, all bugs are shallow, right? And with ECBA, we're often most concerned about the crazy new technology that nobody has thought about before. That's precisely when I think you need more people in the room talking about something, because forget about Mark Eckenweiler, it could be my friend, Nathan Judish, it could be someone at the back of the room who says, this just doesn't smell right.
Well, nothing else to explain the bureaucratic turf envy, right?
Yeah, you're right. So I've painted this mostly as a kind of laudable story about these civil servants, but you're right, there's probably some of the more baser impulses that I'm trying to activate here as well, which is the more power I have, the more important I am, the more I can progress in my career. That's not a bad thing to try and kind of pick at a little bit with this proposal. Yeah, Julie, it's so good to see you.
Hi.
I heard you were in town. That's
So
great.
I was just questioning what your detail in the bazaar is the right analogy here. So if you consider, for example, that every major U.S. company is a chief privacy officer now,
Right.
and the role of the chief privacy officer is in theory to keep this right?
Yeah.
But I imagine if you looked into it, or if you looked at Giudari and Committee's work on what chief privacy officers actually do, you might find that their existence is conflicted.
Yeah.
Because there are structural forces that tend to kind of militate toward a less activist and more compliance-oriented culture within the privacy office as well. Or consider auditors,
Right.
Pre and post Enron and even post PCAOB. There's not, I just wonder how much faith would end up having in this kind of trust.
Yeah, no, absolutely, and I think those are all the correct analogies. I mean, it's possible, and some might even think likely, that if we kind of expand the paths of authorization through main justice, you're just going to get kind of this lockstep alignment of action and interest. And I mean, the best I can offer, and this probably isn't very satisfying, is to say that that's not going to the prior gentleman's question, not my experience with the Justice Department at all. I mean, you think about the types of people that they hire, and they should hire. I mean, part of my prescription in the essay will be hire more civil libertarians, Justice Department, because when I was in the computer crime section, we had a lot of civil libertarians in the office, and it would warm the hearts of the privacy advocates in the room if you could have spent some time at CSIPs, knowing that these are people who took the job, A, because they were computer geeks who didn't understand why they went to law school, but B, like deep in their core thought, I want the government to be able to find criminals, but I'm also worried about personal privacy. There are a fair number of people who are more privacy nuts than they are law enforcement hawks. One other way I'll point this out is, and this is the very first thing I ever wrote before becoming an academic. It's actually not very good. But I wrote an article where I said, it's a good thing that the Justice Department not only interprets ECBA, but the very same attorneys are asked to prosecute wiretappers, because you're likely to engage both halves of your brain, which is, I don't like privacy, I like privacy. I don't like privacy, I like privacy. And so I thought that the result in that case, I guess it's a similar piece to what I'm writing now, was we'd end up in the middle. We'd end up with the bureaucrats themselves trying to strike the balance. So yes, this is a form of trust me, it's going to work out, which you're right to find a little unsatisfying or a lot unsatisfying. Jennifer? Yeah.
Help at all? Oh yeah, there I am. It makes me think of Alberto Gonzalez going to John Ashcroft's sickbed to ask for approval for a warrantless wiretapping over Comey's objection. And I wonder if you think that that story supports you, helps your argument or hurts your argument.
I think it absolutely helps, doesn't it?
No. It doesn't.
Right,
I mean,
so you have James Comey.
We're lucky we know about that, right? And it shows how, you know, sort of personality and circumstance and vagaries can be the thing that ends up resulting in a major policy decision. And it seems to me to be very kind of specific when you want something far more trustable, transparent, and routine when it comes to protecting civil liberties than that.
And Professor Brown, I don't know if I'm way over
Well,
time. I apologize for that.
We got 4 more minutes.
So here's what I would say in response to that. One, if someone argued that you should do what I'm proposing instead of increasing judicial and legislative oversight, I would say, boy, you really misread the argument. Please leave the room now. If this is coupled with legislative reform of the kind that the Digital Due Process Group is forwarding, I can't imagine how this would be worse. I could imagine, based on the last couple of questions, how it might not change much, but I can't imagine how it would be worse to have more eyes, particularly eyes from a different vantage point. Main Justice really does think about this differently than the field. And so to engage them more, I think could only be either neutral or net positive for privacy, especially when we're talking about new things. And again, even in that story, James Comey's the great hero, right? I mean, the fact that we had someone other than the White House counsel with the authority to speak up is exactly what made that story a good one. The story that animates Neil Katyal, of course, is the story of John Yoo. How when we instead pick out one bureaucrat, the one who shares our views, and give them inordinate amount of say and persuasiveness over the entire process, that's when we're most in trouble. But if instead we said, John Yoo, you've got to trickle it up to the top of OLC, and oh, by the way, we're going to get the State Department to write a memo and the Defense Department to write a memo, we're going to be better off. And at the very least, we won't be worse off.
I would just say, you know, perhaps contrary to what some might expect, with that clarification, I think this is a good idea based on the experience of seeing individual prosecutors do stuff that would make Main Justice flip out. And in particular, seeing, you know, they have a surveillance manual at CSIPs that was first written by Oren Kerr with model forms. And I've seen examples of prosecutors taking the model form and then editing it in ways that would have made, that if they had known about it, Main Justice would have gone, please don't do that. The Indie Media subpoena being one example, the preservation orders that were used in Warshawk being another. Preservation orders are, hey, please hold on to what you have so we can come back with process to get it. It's what Richard was talking about. The DOJ manual and the model forms both say very clearly as can be, do not use this for prospective preservation. This is only for them to hold on to what they have. If they're going to do prospective collection of anything, get a freaking wiretap order, because that's a wiretap. In Warshawk, they cut out the line from the order that said, please don't do anything prospectively, and replaced it with, please prospectively collect. And in our opinion, did an unlawful wiretap by doing so. If that had been vetted by DOJ HQ, that would never have happened. The flip side of that, though, is we get stuff like this URL thing, where if we could actually surface the issue of when and whether pen registers can be used to track, to collect your URL stream, that would be really helpful. But in a way, the check of Main Justice prevents us from getting to litigate it because they recognize there's a serious suppression risk there and they try to avoid it.
Yeah, but think about the critique you
well, no,
just made,
it's a perverse.
There's too much privacy in the world, which makes it harder for us to figure out. Right.
And I'm
when you consider the privacy, the secrecy issue, it makes it hard to.
I'm going to exercise moderator prerogative and say, in true intellectual spirit, we should go to lunch and just kind of hash this out. But one thing, and then one thank you. One thing is that oftentimes I think about popular literature and culture and how it informs about such things. And there's this great movie from 1974 made by Francis Ford Coppola called The Conversation. And it stars Gene Hackman, and his character is a surveillance guy. And what he does is he's in San Francisco and he's setting up a surveillance of a couple. And he is actually torn about this because he is troubled by how the information he's acquiring is going to be used against these people. In fact, some people end up dead. And he ends up tortured throughout the movie because of this. And I think I just commend you all to watch this movie. I want to thank our panelists who did a fantastic job in really kind of going along with this dialogue. Yes.
I want to comment on the movie, The Conversation. It was based on the investigative work of a famous detective named Harold Lipson, who died about 15 years ago. And he was a the story which some of you already know, and which is a charming story, which I will not retell, which was one of the early events of electronic surveillance. So I recommend that people read this book, The Bug in the Martini Olive. You'll enjoy it very much.
Good, thank you, thank you. Thank you, gentlemen.